big ET now exclusive. Essar Steel and Ruiyas are likely to approach COC to seek withdrawal of the IBC process. Ashwin is joining us now with all of these exclusive details. And Ashwin, the game has completely turned around. What are you gathering?
That's right. You know, this is perhaps the biggest twist in the tail as far as the race for Essar Steel is concerned. Consider the background. The background is that ArcelorMittal has in fact been chosen as the selected or preferred bidder by the COC. We also have a situation wherein New Metal did not clear the dues that they were supposed to clear as per the Supreme Court order, and therefore were out of the race. And that of course left only two players, ArcelorMittal and Vedanta. And the COC went with ArcelorMittal, and it was widely believed that ArcelorMittal would in fact end up getting the final nod from the COC and in fact scooping up one of the most prized steel assets in India, which is Essar Steel. Now what we are given to understand from our sources is that the promoters of Essar Steel, which is the Ruiya family, have in fact in a stunning comeback of sorts offered to settle the case. And what we are given to understand from sources is that the Ruiyas may in fact reach out to the COC, which is the Committee of Creditors, and they may seek a withdrawal of the entire IBC process. Now what sources are telling me is that under the Insolvency and Bankruptcy Code, or the IBC, there is a section called Section 12A. And under Section 12A, if the promoter of the debt-ridden company wants a withdrawal of the IBC process, they can do that. So I'm given to understand from sources that this particular recourse has been sought by Essar Steel and its promoters under Section 12A. Obviously, this means that at the end of the day, the promoters of Essar Steel, which is the Ruiyas, are in fact in a position to pay these dues, and these are dues relating to Essar Steel, which owes more than 45,000 crore rupees to many lenders. One thing is very sure, clearly whatever proposal has been made by the Ruiyas, or which is likely to reach the COC officially, whatever proposal that is, that proposal is likely to be higher than the amount offered by ArcelorMittal, and that will definitely put the COC or the Committee of Creditors in a spot, because on one hand they have chosen the H1 bidder, on the other hand you suddenly have this mouth-watering proposal coming in from the promoters of the defaulting company saying that they want to withdraw the IBC process. But at the end of the day, one needs to keep in mind that under the IBC and or the Insolvency and Bankruptcy Code, any sort of entertainment of a withdrawal of an IBC process, that can happen only subject to the approval of the COC, which is the Committee of Creditors. It can't happen beyond that. So that's what we're given to understand from our sources. In fact, for more details, we're now joined on the phone line by Abizar Divanji. And Abizar Divanji is, of course, leader of financial services at EY. Abizar, thanks so much for taking out time and joining me on this breaking news. First thing I want to pose to you, can a Section 12A proposal by the Ruiyas at this stage, when an H1 bidder has been selected by the COC, be entertained, if at all? What do you think are the chances that the COC might entertain this?
So I will tell you the rule. If you read Section 12A in the language that comes out, basically says that any withdrawal under 12A will require 90% of the approval of the Committee of Creditors, and 2, it has to happen prior to calling of an EOI. These are the two prime conditions. In this particular case, the EOI has been called out. But the debate that does remain is the fact that because the rules on the 12A came in much after the process was already in place, how the COC interprets a higher bid under 12A will be an interesting thing to see, because it's an interim provision. Otherwise, in the normal course, for example, it would be very difficult for a COC after the receipt of a bid to entertain any Section 12A application, because it has to happen before the EOI, forget the bid. But in this particular case, as I reiterate, because the process was already on, it's quite possible that interpretations could be different if the amounts are higher. But I think it's a little bit of a far cry.
Right. Abhijit, stay on with us as we analyze this sudden twist in the tail as far as the race for Essar Steel is concerned. A last moment attempt made by the promoters of Essar Steel, the Ruiyas, to in fact offer to pay dues to the lenders and then withdraw the entire IBC process. Nilang, correct me if I'm wrong, but can a Section 12A application under the IBC be entertained for withdrawing the IBC process after the submission, of the expression of interest or EOI? And do you think perhaps this will be quite a difficult decision for the lenders to make at this stage if the overall amount offered by Essar Steel promoters is more than what Aslar has offered?
No, that's right. I mean, I think 2 points to make. One is that the regulations are fairly clear that the withdrawal of application can be made by the applicant themselves. So in this case, SPI and Stan Chart, and can only be made, in the first 75 days, which have obviously expired. And actually, thirdly, the regulations which brought in, or the amendment regulations which brought in this ability to withdraw, applies only for IBC cases which started after those regulations came in. So in all these counts, I think I struggle to see how they fit it in within the current regulations. But to the extent they're going to the Supreme Court, Ashwin, the Supreme Court obviously has its powers under Article 142 and it has used these powers in the past to pull companies out of the IBC, to basically make an exception and say, well, if lenders are getting their full dues, I'm using my discretion. Whether the Supreme Court will, in this context, given, the extended process, the fact that Arcelor has also spent a lot of time already, in terms of time, money, effort, I don't know. I think that's the interesting thing we have to look out for now.
On the phone line by Mr. Ashwin Parekh. Mr. Parekh, what do you make of this last moment twist in the tail from the Ruiyas? They are likely to in fact take recourse under Section 12A, as both our panelists were pointing out. The last decision, of course, or the ultimate decision in this particular scenario, at least from the IBC point of view, is limited to the COC or the Committee of Creditors, who by 90% of majority need to give a go-ahead to this, and it's only then that the proposal of the Ruiyas will be entertained. But in this kind of a scenario, you have an overseas player like Asla Mittal, who has fought a legal battle, or who's fought a legal battle for almost a year now. They have bid aggressively. It's been a fierce corporate bidding war. If the COC goes ahead and accepts this proposal, do you think this perhaps paves the way for more litigation? Because Asla Mittal will definitely be disgruntled.
True. I mean, see, I'll tell you, here is the first case, a major case, after a long battle, after a long time, that we thought, may get to a resolution point. Now, this is a new development, of course. The only thing is somewhere along, I do believe that the earlier reform, that the government had proposed, I don't know whether it's still enacted in the Act or otherwise, where they said that the financial creditors will all reach an understanding, an agreement. And once they reach the agreement, then, all of them have to really, that is who in fact participate in the agreement, have to really work with the lead banker, and then there cannot be any dissent or any kind of, let's say, vote against the decision. So I don't know whether in this case they went about doing that. But I would still personally believe that 90% of the COC will see, some sense in sort of, taking this attempt out and complete the process. Within NCLT, IBC itself, and not let it get dragged into the courts, basically.
Parekh, Abhisar, that's a fair point with Mr. Parekh makes, that whether or not such an attempt at this 11th hour by the Ruiyas should be entertained. What do you make of it? Because if this was indeed the scenario, then this proposal could have been made by the Ruiyas, which are the promoters of Essar Steel, at a much earlier stage.
No, that's all good to say. Now, I have only 2 points here. As I said, when Nilang said 75 days, I don't think it's 75 days. It's actually the date on which the EOI, before the EOIs come in, and the EOIs have to come in within 75 days. So the important date here is the fact that it should have happened before the EOI date. The point in law that will ever be debated is the point that all these conditions, the EOI date, etc., happened much before 12A even came about. So is there then a transitory provision which will not apply to this particular case? That has to be legally examined. And frankly, it's not a question of when they put it earlier, did they put it now? I think it's a question of law to say that can they put it or can't they put it? And if they can put it commercially, can the Committee of Creditors accept a bid which is higher? So I think the hinge here is more on the fact that whether a transitionary provision will apply, because 12A was introduced after the EOI date. That's all I would say.
Right. Abhisar, you've laid down the background for us. Let me now get the clarity from the lawyer on this breaking news panel. Nilang, your take on what Abhisar has just shared. It's a nuance, but it's a legal nuance. So what do you make of it?
No, I think it's along the lines of what I said earlier. I think, as Abhisar points out, the deadline is the expression of interest date, and then the regulations say the expression of interest must really be, published within 75 days. Now, as Abhisar points out, while this is what the law says, all these regulations came in long after the expression of interest for Essar Steels was actually issued. Now, I don't think that's germane to the issue here, because really the law has given the ability, the law has laid out how that ability must be exercised. The law has also stated in the amendment regulations that they apply to IBC processes which start after these amendments came in. So in many senses, really, the Essar Steel IBC process does not have the benefit of this withdrawal. It simply does not, as a matter of a plain read of the law. Therefore, it's up to the Supreme Court. And let me put it this way. The Supreme Court doesn't need 12A. It doesn't need the ability to withdraw. It has Article 142. It has in the past, even before we had these amendment regulations, it has actually pulled out cases out of the IBC. We know a number of cases where, the Supreme Court has said, I'm using my Article 142 jurisdiction to pull the case out of the IBC. And in fact, it was the Supreme Court's comment in one of these cases where it said, listen, too many cases are coming to us which we think merit withdrawal from the IBC process. So can, the government please get together and bring in a provision which allows the COC to pull it out themselves so that cases don't have to come to me, or come to us rather. And that was the reaction. The Article 12 is a reaction to Supreme Court's comment. So it still retains the right, and I do think that if Essar Steel is going, the RIAs are going to Supreme Court, they're better off using the 142 jurisdiction than relying on some nuance of 12A.
The 142 jurisdiction, of course, has been used by the Supreme Court, and perhaps that's the jurisdiction which, in fact, based on a request from the COC, the Supreme Court decided to give yet another chance to ArcelorMittal and New Metal to clear their dues, even though they had found them ineligible under Section 29A. Mr. Parekh, from a COC's point of view, from the lender's point of view, we have always seen this ongoing debate between following the procedure versus maximization of value. But, wouldn't you say that the Essar Steel case has been perhaps stretched to the hilt as far as the maximization of value is concerned? You've had very aggressive offers, but from a commercial point of view, do you think the lenders would be tempted to entertain this proposal if it was significantly higher than ArcelorMittal's final bid?
I mean, I don't know. I mean, in COC also deciding on something like this, they'll certainly look at the background of the promoter who's now coming back with a proposal. I mean, if they do believe that in the past, the promoter has gone into major restructuring programs, and the COC, the creditors, the financial lenders have suffered on account of that, then they may consider that as an important aspect in this decision as well, to my mind. I mean, we know that from 2000 onwards till date, there have been steel restructures, and Essar has been one of the major promoters. I would still believe that some amount of, between the two principles, that is the maximization of value and the sanctity of the process, even brushing that aside, I would say COC may perhaps look at the background of the promoter, and may 90% of them or more may decide not to really entertain this. I don't know.
Desai, please hold on to your thoughts, because our news break has been confirmed. I have got an official release that has been sent to me, and I'm just going to read out a few of the details from this official release as we go on and analyze the implications of this sudden move. So what it says is that the board and shareholders of Essar Steel have offered to make a payment aggregating to 54,389 crore rupees to creditors of all classes under Section 12A of the IBC to withdraw the company from the corporate insolvency resolution process. So this is what the main takeaway of this press release is. Abhisar, what do you make? It's a very aggressive offer, 54,389 crore rupees, and that is definitely higher than what ArcelorMittal is paying.
It's a dilemma, yes, but I go back to the same question that whether they should or should not, whether they protect the sanctity or no, whether the Supreme Court decides to allow under 142 or no. I think this will be a very good case in front of us once the offer is now put on the table. One aspect is that the maximization of creditors should be followed. And at the other end, we already had a process which got approved with 92% approval of the lenders today. So which of that will be accepted is a dilemma. We'll have to see. Frankly, all of us in this room are facing it for the first time.
Absolutely. This is quite a peculiar situation, and this is indeed the test case in India as far as IBC is concerned. Nilang, our newsbreak has been confirmed. It's an offer of 54,300 odd crore rupees that has been made by Essar Steel and its shareholders. Your reaction, because now it's official and it's quite a tempting offer as far as the COC is concerned. But should it be entertained? We are coming back to that billion-dollar question again and again. Nilang, your thoughts?
I think it's phenomenal. I mean, back from, not only the initial offer, but also if you think about the offer made by Essar Steel to its JLF members back in May 2017. No, I think this is a bonanza for the lenders. Obviously, they'll have to propose this to the COC first, wait for the COC's reaction, and if the COC says yes or no, my fear is we're seeing this back in the Supreme Court. And it's going to be back to the Supreme Court to decide, whether to maximize value and give that extra 10,000 crores to the lenders, or preserve the sanctity of the process. And, what do you really tell ArcelorMittal after 14 months of battling it out in time and effort, that someone can change the goalpost a little and kick a goal and still score a goal, after the 90 minutes up? I mean, it's a really, really difficult one. But it's worth 10,000 crores, so it's not a small sum. I don't have an answer for you, Ashwin, I'm afraid, which way to go. I mean, my preference as a lawyer would be to keep the sanctity of the law, but 10,000 crores is nothing to be sniffed at.
Just hold on to your thoughts. I'm just going to read a few more details from this press release that has now officially come in from Essar Steel. And, they're clearly making a strong point, and they're trying to tell the lenders how their offer is higher than the ArcelorMittal offer. What they have told the lenders is, if the COC were to accept the resolution plan currently under consideration, and we're all aware that that is, of course, ArcelorMittal, it will have to settle for a sizable haircut. So, Essar Steel is clearly telling the COC, if you accept AM's offer, then you'll have to go with a sizable haircut. So, that's something that you need to keep in mind. Then the statement also goes on to say that the offer does not provide for meaningful payment to operational and other unsecured creditors. So, basically, they are taking pot shots at the offer made by ArcelorMittal, and they're telling the COC that, listen, if you don't want a significant haircut, then you please go ahead and consider our proposal. Ashwin, what do you make of these attempts being made at the last stage to, in fact, size up the Essar Steel proposal versus the ArcelorMittal proposal in terms of quantum, in terms of haircuts?
Well, actually, it's not this case now any longer. I mean, this case really becomes far more interesting. I mean, somewhere along when we started with this reform, right earlier on, we had said that both the principles, that is the principle of value maximization for the creditors and the principle of sanctity of process, both have to really prevail. Both have to be equally followed and adapted. So in a situation like this, and then of course thereafter we saw that there has been a gradual compromise on the process sanctity part, so we've seen so many other cases in the past, and this may be only one more such case where the process sanctity is being compromised on the grounds of the first principle, that is the value maximization. My only worry is it has large implications to the investors. I mean, in which case now what may happen is that the investors may shy away from bidding. I mean, knowing two things. One is that the whole process is going to be long drawn. And the second is the conclusion still remains out of sight. And if they do participate, then it may end up being a price discovery kind of an exercise rather than anything more than that, Ashwin. So I thought somewhere along we'll have to go back to the fundamentals and within the NCLT IBC reform, we'll have to say that both are equally. So if there was a process and if the process dates are over, then once again, do you really keep on accepting the proposals is something which I think will have to be really re-examined, I thought.
There's also a quote in this official statement that has come in from Mr. Prashant Ruya, a director at Essar, and Mr. Ruya has said that Essar Steel believes that their current proposal will provide 100% recovery to secured creditors and lenders and maximum recovery for unsecured creditors. He's also gone on to say that this sort of supports the entire concept or principle of value maximization, which is the bedrock or the underlying principle of the IBC. So those are two comments that have come in from Prashant Ruya, the director at the Essar Group. Nilang, if I could get you in over here, what is the scope for litigation going ahead if this is indeed, in fact, approved or gets the 90% nod from the COC? You know, there will be a lot of disgruntled parties, but at the end of the day, you know, if the COC were to take a purely commercial call and say that as per value maximization, this is the best offer on the table and let's give them a chance. But doesn't that open the floodgates to litigation? The obvious one who will be disgruntled would be Asla Mittal. But what about the likes of Vedanta?
Yeah, well, I mean, I suppose Vedanta has been a bit of a side player here. I think, you know, from Arcelor's perspective, they've got a much stronger case because, you know, they've been in the process from the beginning. They've gone through the process. They've been declared H1. They've had, as you know, it was just said on the call that they've had a 92% vote from the COC approving the resolution plan. So they're on a stronger footing, really, where if at this stage they were to be pulled out and the company to be handed over to someone else. So I see litigation here for sure, one way or the other, and I don't think we're going to see an easy answer to this at all.
Right. Abhisar, do you concur with Nilang over there in terms of the potential litigation that may or may not happen?
Obviously, there's no easy answer. There is a dilemma in front of the bankers too, frankly, where, of course, it's all for the betterment of Indian banking in that sense, because there has been a tug war between two people. And there always is a dilemma and will be a dilemma between the fact that you go for a higher value and a more maximized value, because the other issue, don't forget, is that there is a bunch of operating creditors who seem to be now getting a better deal because clearly the bankers have got 92% recovery. Now it is the other guys who are getting better recovery, and they are not part of the COC. So it's the first time that a fiduciary duty of the COC effectively is going to also come to light in some form. But, you know, it's a battle between price and process, and one will have to see where it ends.
On the head, Abhisar, it is at the end of the day a battle between price and process, and this is not the only case under the IBC where this battle is being run. It's also noticed in other similar cases, like for example the race for Binani Cement. We have seen litigation on similar grounds over there. We do have the benefit of a Supreme Court order in the Essar Steel case, but I don't think the order specifically laid down. At the end of the day, given a choice between procedure and value maximization, what should get preference? Ashwin, am I right in saying that?
But, you know, I mean, I suppose we have to really go into more detail as well. I mean, this 54,000 crore offer that, let's say, that we have now from the promoters, I mean, that also has to be, the bid has to be examined. How much of it is upfront? How much of it is coming later? You know, I mean, in what form does it come? So, I mean, those details also will have to be studied if we go strictly by the value maximization principle. Because value maximization also, I mean, if there is something which comes up, let's say, later, then the time value of that has a different significance, I mean. And then of course, the extent to which, let's say, the COC or the extent to which the financial lenders and the other lenders can really rely on. This will also play a part, I suppose.
You know, at the end of the day, at least I've been tracking IBC for the past few months, and most stakeholders are playing safe. Whenever it comes to a controversial decision, they have opted to either check with the NCLT. If they lose over there, then they go to the NCLT. So do you think in this particular scenario, we are looking at a possibility wherein the COC, rather than taking a decision on their own, might go to the NCLT or NCLT? And I'm saying this in the background of what the Supreme Court has also said, that the NCLT and the NCLT should also, you know, use their discretionary powers when they, you know, entertain appeals. But this is a serious question, and whatever answer is given by the COC, that could turn the entire bidding war on its head. Nilang, do you think perhaps that would be a safe route for the COC to maybe move a judicial forum and seek clarity?
Correct. I mean, see, I think I see two approaches here. Either the COC simply says, no, we read the law, we have no option. And if they do that, then of course, you know, Essar goes to the Supreme Court and either asks well, actually not either, ask for both an interpretation of 12A, failing which request them to use 142. The other route I see is, of course, that COC says, not so sure, and let's go to the NCLT and ask for a clarification. My worry with the latter approach is then that goes through 3 rounds, NCLT, NCLT, and then finally the Supreme Court.
But all three, all these parties have already, been a part of an earlier proceeding in the Supreme Court. So, Abhisar, do you think that it is possible for them to skip the NCLT routes and perhaps directly move an application at the Supreme Court, asking you on this issue?
I think it will go through a due process court. I don't think it will directly go to the Supreme Court. I agree with Nilang. It will have to go through the NCLT, NCLAT, and above. Because and also, frankly, given the fact that the same judgment from the Supreme Court actually says that the court should not interfere in commercial matters, it may then go directly to the Supreme Court on the 142. But apart from that, I don't know. I think they may get the COC to take a commercial decision. And if that commercial decision is something which requires a 142, then it will go up to them.
Abhisar, it's come to a stage where it's, not just about a commercial decision, but also what could be viewed by the other party as a controversial decision. If I was in the shoes of the COC, I would really not want to be in the shoes of the COC right now, because on one hand you have the Supreme Court saying NCLT don't entertain commercial decisions. On the other hand, you have the COC suddenly left with this juicy proposal, and they also have to look at process, they also have to look at value maximization. So I guess that the lenders would be burning the midnight oil in the days ahead to decide to go ahead and what to do in terms of this sudden bouncer that has come in from the Ruya promoters. In fact, I'll take closing comments from all three of you now. Nilang, your closing comments. Do you expect the COC to accept this proposal? Yes or no?
I think they would love to accept it. I don't think they will be able to accept it without clarification from a court, because it would be the more conservative thing to say we don't see an ability to do so and therefore let's go to a court. So no, I don't see them saying yes without getting the blessing of a court.
Abhisar, your closing thoughts. Do you agree with Nilang that the COC is unlikely to take a bold decision and accept this proposal without getting a go-ahead from a court?
Oh, absolutely. I think this has been the most high-profile case. So I think there will be a lot of deliberation, a lot of consultation, including court interference before it actually happens. But frankly, I wish both the participants the very best and the COC the ability to take the right decision.
Absolutely. It is at the end of the day the toughest call that has to be taken by the COC. In this particular case, they have had to take several tough calls. They've taken judicial recourse. But this one, I think, is the most toughest decision yet in this Essar Steel case. Closing thoughts from Ashwin Parekh as well. Mr. Parekh, would you like to share your closing thoughts?
Yes, sure. So, look, the way I'm looking at it is, the whole reform initially, Ashwin, was aimed at ensuring that the financial lenders do not get exposed later on, once they make a decision to any further investigation or litigation. Particularly investigation. And we've seen that even after, let's say, some of the bankers retire, they come under investigation. The whole idea was to make sure that fast decisions can be made. And that's the reason why the entire COC and the process part was established under the NCLT IBC reform. Now what may happen is we are not just talking about the two principles. We are also talking about whether there can be, therefore, intervention from either the three sets of, let's say, steps that the COC is expected to carry out or go directly to the courts. But in addition to that, once again, if the COC is confronted with making a decision, then we cannot really expect a decision to be forthcoming so fast. And then they will have to take a safer route. Just in the fear of any future, let's say, investigation or reopening of the case, basically.
In the past, we have looked at a scenario wherein we have said that this race for Essar Steel is a race between ArcelorMittal versus New Metal versus VTB versus JSW Steel. Who would have thought or imagined that one day it would boil down to ArcelorMittal versus none other than the promoters themselves, the Ruyas. Gentlemen, thank you so much for taking out time and helping us dissect this breaking news on ET Now. Stay tuned to the channel for more news and updates.